Welcome back to Lost Dash Channel. My name is Anton Bieltsin. I'm an attorney in the Southern District of California here in San Diego. As you probably already know, this summer the Supreme Court came out with the case Bruen, which clarified that the government cannot restrict your Second Amendment rights unless the regulation is consistent with this nation's historical tradition of gun regulation. Now, there are many videos on YouTube discussing Bruen, so I'm not going to go in detail about the case today. Instead, I will link some of those videos that I find the most helpful in the description under this video. And I ask you to watch some of them to have a better understanding of what Bruen did. Effectively, the case Bruen changed the way we look at the Second Amendment regulations. We now have to look at the historical traditions in this country of gun regulations. And of course, as you can predict, there are going to be many cases working themselves up through the judicial system where individuals are challenging a certain gun regulation. Today we're going to look at one of those cases that came out from the Northern District of Florida, where a federal Florida judge tosses a lawsuit where individuals said that a federal statute which prohibited and effectively banned individuals who have a medical marijuana card from possessing firearms. The federal judge said that that prohibition and restriction does not offend any constitutional rights of those individuals. Before we go on and discuss the case, I want to thank you for watching me on YouTube and subscribing. And if you're listening to the podcast version of this recording on Spotify or Audible, please give it a 5-star review rating. And again, before we go on, I want to thank those individuals who purchased some of my merch from my website at lostdash.com. The Do Not Arrest Me t-shirts, the Padre t-shirts, and the stickers. I thank you for supporting this channel. Let's go ahead and discuss the case.
Hello, this is a prepaid collect call from
Lost Dash Law Firm
at Western Region, San Diego. To accept this call, press 5. To refuse this call, hang up now. Thank you for using T-Netics. You may start the conversation now.
Today we're discussing Freed versus Garland, which is a North District of Florida case where petitioners are challenging a federal criminal code 18 U.S.C. 924A8, which bars unlawful users of any controlled substance from purchasing or possessing firearms. Now, the petitioners is Freed, who is a commissioner in charge in Florida of giving out concealed carry licenses, and he's in part in charge of medical marijuana cards. There are also a number of citizens. One citizen is an individual who went to purchase a firearm and was turned away after he marked a box on the purchasing form stating that he's a medical marijuana user. And there's another citizen who is in fact a medical marijuana card holder. He uses medical marijuana, and he's afraid to purchase a firearm because he says he might be prosecuted under this statute, 18 U.S.C. 924A8. The petitioners together challenge the statute and say that it violates their Second Amendment rights to bear and possess firearms. They also say that it violates the Rohrabacher-Farr Act, which prohibits the Department of Justice of using funds in order to prosecute and go against the state implementation of their own medical marijuana acts and laws. Now, the government answers saying that the petitioners do not have standing and the plaintiffs also lack any form of relief because they did not state enough claim for any form of relief.
From New York, Bill O'Reilly.
Good evening. Boosted by special sales, the Christmas shopping season began today. Retailers reported large crowds. Back in a moment.
I'm going to look down at some notes, but here's what Judge Windsor says from the Northern District of Florida. He cites the United States Supreme Court New York State Rifle and Pistol Association versus Bruen, which again clarified that the government cannot restrict your Second Amendment rights unless the regulation is consistent with the historical tradition of firearm regulation. Now, when we're ascertaining the historical firearm regulation to the modern one, it requires the government to determine whether two regulations are similar in nature. Now, again, this is the government's burden to prove that there are two acts or two laws that are similar. But again, historical analog does not mean a historical twin, says the judge. These are two acts that could be different. We're just looking at similarities. And the judge finally says that modern statute and historical ones, in keeping guns from those acting unlawfully, are comparably justified, as both further the government's long-standing goal of keeping firearms in the hands of law-abiding citizens. What does he say? That we have a tradition in this country to keep guns away from criminals and keep them only in the hands of law-abiding citizens. And if we look at medical marijuana or possession of any narcotics, medical marijuana still remains unlawful under federal law. It is a controlled substance. And so he says there's an analog. He says that a person who admits to using a controlled substance and marijuana remains such a substance, the law does not infringe on the Second Amendment rights. But what about the Farr Amendment, which says that the federal law, the federal Department of Justice, would not spend money in going against the states in implementing their own medical marijuana laws. Judge Windsor says that the amendment prohibits the Department of Justice of allocating the funds in order to fight the medical marijuana in those states, but by prohibiting an individual from possessing firearm, that does not change how the state would use the funds themselves to have the programs with medical marijuana, and the federal government does not infringe on that state right. They're still not spending the money. They're just keeping the law on the books. And so the federal judge tosses the lawsuit and says that in fact these individuals did not have their Second Amendment rights infringed. Now I'm going to leave you with a little quiz. Do you agree with this decision? Because most likely it will be appealed and it will go further up the chain to the appellate court and possibly later go in front of the Supreme Court. Because do you think that 924A8, which bars an individual who uses medical marijuana, should be prohibited? Do you think there's an analog in the history, in our traditions, in barring those individuals? Leave your answer in the comments below. Let's have a good discussion here. I hope you enjoyed this video. Please click like, subscribe, hit that bell notification button so next time I post, you'll be first to know. And if you're listening to the podcast version of this recording, please give it a thumbs up, a 5-star review rating on Spotify or Audible. And again, thank you all for purchasing the merch on my website at loststash.com/merch. Thanks for watching.